جی سلمان, thank you. دیکھیں, now first I just want to recognize that this is quite a difficult situation. There are both sides, there are, arguments on both sides. Obviously, پہلا argument تو یہ ہے on those who believe کہ یہ نہیں ہو سکتا, and that is most likely the argument that we know historically the Supreme Court, which jealously guards its own jurisdiction and its own powers, so that is the side that one can predict they will most likely take. is کہ through ordinary legislation آپ ایک right of appeal نہیں create کر سکتے from an exercise of a constitutional power. یعنی کہ 184(3) کے اندر آپ ایک اپیل کا رائٹ نہیں کر سکتے, particularly, and I think the argument that others are making is because constitution میں already appeal provisions ہیں, so you cannot create then another appeal provision. میرا جو اپنا view ہے, I think Article 191 allows Parliament to enact a law provided that it is not conflicting or within the boundary which has been created in Entry 55 of the Federal Legislative List. Entry 55 now at first says that the Parliament can legislate in respect of other courts except the Supreme Court. So یہ ایک exception ہے, but then there's a further exception کہ جہاں Supreme Court کی jurisdiction کی expansion کی بات ہو یا کوئی supplemental powers ہو which are provided to the Supreme Court, اس حد تک the federal legislature can legislate. تو اب سوال یہ ہے کہ this entire bill, what is it doing? Is it expanding the jurisdiction of the Supreme Court? Is it providing the Supreme Court with additional power? Now, there's another way to look at this. Entry 55 also restricts the federal legislature from curtailing the jurisdiction of the Supreme Court or curtailing any power of the Supreme Court. یعنی کہ اگر Supreme Court کے پاس 184(3) کے اندر یا suo motu jurisdiction کا ایک power ہے which has been held by the Supreme Court itself while interpreting the Constitution, which it can, تو اس کو ordinary legislation کی through curtail نہیں کیا جا سکتا. میرے نزدیک any procedural rule جیسے اس بل میں ہے to basically regulating the constitution of benches, one, and secondly providing an appeal provision. I believe کہ یہ دونوں چیزیں do not restrict the constitutional jurisdiction and the power of the Supreme Court. They merely regulate the internal matter of the Supreme Court in the sense that one, who will be the Supreme Court or which number of benches will constitute the Supreme Court for that purpose. And if agar usko hum 175 ya 175 I believe ke saath padhe, so I think that is perfectly consistent. When it comes to an appeal, I mean, even if we cannot argue that that is an expansion of the Supreme Court's jurisdiction, one cannot certainly argue that that is a restriction of the Supreme Court, because at the end of the day, the Supreme Court is able to exercise its jurisdiction. Wahi suo motu jurisdiction will still be exercised by the Supreme Court. Merely an additional right of appeal is being provided. Acha, ab isme we already have, I believe, an example in our high courts. Article 199 की जो decisions होती है exercised by a high court, they are also appealable under the law reforms ordinance in an intra-court appeal. اب انٹرا کورٹ اپیل وہی ہے کہ ہائی کورٹ کے اندر ہی ایک اور اپیل کا رائٹ دیا گیا ہے in certain circumstances and conditions against an order passed under Article 199. So this, I believe, can be considered as an intra-court appeal for the Supreme Court. And now, so there's that argument. I think this can be argued either way. But why I believe that it should be argued in a way to allow the legislature to do this. Now, keeping all motivations of PDM to a side, wo aap side pe rakhein. Hum future generations ki baat karte hain, and particularly the rule of law. Acha, rule of law mein do concepts aati hain, ek separation of powers and independence of the judiciary. And a lot of commentators have said that ye jo Supreme Court ka bill hai, this is against the independence of the judiciary. With respect, I totally disagree. Independence of the judiciary ka ye matlab nahi hai कि in judiciary अपने लिए कानून साजी करेगी for its own procedure और वो अपने आप को हर सूरत हाल में regulate करेगी. Now, अगर आप बाकी jurisdictions की कॉन्स्टिट्यूशंस और लॉ पढ़ें, आप ऑस्ट्रेलिया को देख लें, आप यूएस को देख लें, और बेशक यूके को भी देख लें, उधर भी देयर इज उनके जो कॉन्स्टिट्यूशंस हैं या लॉज है, उसमें सुप्रीम कोर्ट की जो सुप्रीम कोर्ट के पास है इख्तियार कि वो अपने लिए खुद रूल्स बनाए, बट वो उधर भी हमेशा सब्जेक्ट टू लॉ होता है. और ये आप देख सकते हैं उनके कॉन्स्टिट्यूशन में इट्स ऑलवेज सब्जेक्ट टू लॉ, यानी कि एंड द एक्सेप्शन इज कि सुप्रीम कोर्ट अपने लिए रूल्स बनाएगी, बट देयर इज एन ओवर आर्चिंग अंडरस्टैंडिंग कि लेजिस्लेचर कोई भी लॉ बना सकती है on how cases must be decided. And that is very important for the rule of law and the separation of powers. Separation of powers का मतलब ही ये है कि legislation legislature करेगी and application or decision making वो judiciary करेगी. So I believe that it is important that if this matter ever goes before the Supreme Court, my hope, although I'm not my desire, but I'm not very hopeful, because I believe हमारे Supreme Court jealously guards that avenue. ये हमने मुनीर भट्टी के केस में भी देखा, जिधर जुडिशल अपॉइंटमेंट्स के सिचुएशन में the legislature was told to amend it, and practically the parliamentary committee, its wings were clipped basically. So now you have practically a toothless parliamentary committee which basically rubber stamps in the judicial appointment process. So ye mera view hai. Or second, this is my overall view now in the current context, what is important and why a lot of us, Zafar Saab, all of us we've been harping on and on about how because of the internal divisions this will cause numerous problems. One avenue where it will cause problem is also with regard to this bill. Once this is enacted, तो सवाल सिर्फ ये नहीं है कि क्या वो कोई गवर्नमेंट अपील करेगी इस डिसीजन को, बट सवाल ये भी है कि इस बिल की कॉन्स्टिट्यूशनैलिटी जब चैलेंज होगी या इस पे अगर कोई सुओ मोटो सुप्रीम कोर्ट लेगी, तो वो कौन से जजेस डिसाइड करेंगे? क्या फिर से यही 3 जजेस डिसाइड करेंगे? So with each passing day, or we've been talking about the constitution of benches and the exercise of power by the CJP, and some have accused him of doing this in an arbitrary fashion, only having like-minded judges sit in a bench with him. But so अब over time जितना भी ये मौका आएगा और ये difficult issues आएंगे before the Supreme Court, we cannot have a situation where those same judges decide the same issues to provide that level of consistency. So internally, the Supreme Court must resolve its own issues. They must get on the same page. اگر وہ سارے مل کے ڈیسائیڈ کرتے ہیں کہ یہ بل غلط ہے, انکانسٹیٹیوشنل ہے, that's fine. لیکن ان کو مل کے, اور I believe in a larger bench with as many judges as possible with diverse views, یہ decide کرنا ہوگا. If not within the next few months, maybe after a year or whenever that time comes. So those are my thoughts on this particular bill and the appeal provisions.